All right. Hi again, everybody. This is Paul Singer. Once again, I'm partner and chair of our state AG practice here at Kelley Drye. And welcome to our latest installment of our state AG webinar series, where today we are thrilled to have join us representatives of the Kansas Attorney General's Office, Amber Smith, who's Deputy AG for the Public Protection Division, and the great Joe Sciarrotta, who is the Chief Deputy of the Kansas AG's office, one of the very rare multiple state chief deputies that exists out there. Joe, I certainly appreciate you joining us for today's conversation. And our topic today is small state, big impact, artificial intelligence and protecting children. For those that follow our state AG blog, there has been a tremendous focus at the AG level on artificial intelligence and the potential for abuse and harm that can occur in the space. Obviously, there is, as an AG and as someone who spent a long time in an AG office, there is a constant balance that you have to have between, both encouraging innovation, but also protecting your consumers from the harms that can occur with that new innovation. And so really excited to do a deep dive into that topic today. As usual, I am joined by my colleagues at Kelley Drye, Abby Stempson, Beth, Chun, Andrea deLorimier, who make up our state AG team here at the firm. A couple of housekeeping things before we jump in. First, if you have questions, please use the Q&A button that you can find at the bottom of your screen. We will do our best to monitor questions and respond to those as they come in. But if we're not able to get to anything, we will do a follow-up blog post about today's webinar where we can try to address any outstanding questions that exist, as well as, we can always be contacted after the fact, and we'll make sure to include our contact information for anyone that wants to reach out with any follow-up questions. Also, for those that are seeking CLE credit for today, I will be reading a CLE code at some point during today's presentation. You will use that code on a CLE submission form that we will circulate a link for, and you'll just need to make note of that 4-digit code. I will read the code out twice and only twice. And so after that, you will not be able to get CLE credit. So please make sure to make note of that code. So with that, I think we can start our webinar today. If we can go to the next slide real quickly, we will, just in terms of our agenda, we're going to start things just talking generally about the sort of higher level principles behind consumer protection in Kansas. We will then turn to our consumer protection lightning round. For those that have been on our webinars before, this is where we ask a series of very specific questions about Consumer Protection Authority in Kansas. We like to do this because it's a nice way to compare how different states' authority might vary from state to state. And so we'll get into some specific questions about Consumer Protection Authority. And then we'll get to our main topic of AI and the efforts in Kansas to protect children. So with that, I think I am passing it off to Abby. So just once more, just a big welcome to everybody.
Thank you, Paul. And Joe, we're going to start off with you, if we can go to the next slide, talking about consumer protection in Kansas. I mean, as chief deputy, you have a huge role, and maybe you can kind of describe to folks what exactly a chief deputy does, especially considering the fact that this is the second state where you have had, a high-level front office position. And tell us just how you help set what consumer protection in Kansas means.
Yeah, well, let me just give you a summary of the office and kind of what General Kobach has done, and then touch on that a little bit. The Kansas Attorney General's office currently is about approximately 190 total employees. 57 of those are attorneys. We also have, uniquely, many states do not have this, we have the Kansas Bureau of Investigation, KBI, under the AGO umbrella. And they bring another 400 employees, and they're doing, high-level investigations around the state. They also have some very impressive crime labs throughout the state doing various testing on their investigations. So that's a unique component of the office. Sometimes we're able to partner with them on issues, especially in our criminal division, not as much in our consumer protection area, but there are resources there potentially if we need to bring them to bear. Since taking office in 2023, Kansas Attorney General Kobach has joined consumer advocates nationwide. Very important, and I think an important role for Attorney General offices, something that I was very proud of what we did in Arizona when I was there. And General Kobach has carried that mission forward here. It's to educate and empower citizens to recognize and report and avoid scams, as well as deceptive business practices. They're ever present, they're every day, they're coming from multiple sources. He's also made the Kansas Attorney General's office a national player when it comes to investigating and holding large companies to account. And he's done this with the great leadership of Amber and her team over in the Public Protection Division, while also investigating and civilly prosecuting local businesses for misleading consumers. So we try and keep the eye on the ball of big and small, realizing that those impacts can be significant, even if they are smaller businesses here. Those scams sometimes are even larger to the individual when they come to the various things I'm about to talk to. So the Consumer Protection section of the Kansas Attorney General's office receives consumer complaints on a multitude of topics and issues. Of particular here on a statewide basis include automotive warranty and used car sales practices, general construction, remodeling and repair, internet scams, identity theft, crypto scams, generally financial scams, but in particular we've seen a rise, and we can maybe talk about that a little later, on cryptocurrency and crypto ATMs, and the no-call violations. So General Kobach realizes the important role that consumer protection has to the daily lives of Kansans, and sometimes we're the only voice they have. Like Arizona, we try and seek restitution when we can in these cases, not just civil penalties, but also a very important component is the injunctive relief that you can get, whether in terms of a settlement or a court order to correct bad practices of companies and to hold them to account not only in the instant, but for years down the road through that. So we seek to have a wide-scale impact on protecting Kansans by holding big companies such as tech and ticket companies and healthcare and pharmaceutical companies accountable for suspected violations of the law. So the Kansas office is small, but really believe it's mightier than it's ever been. And so the role of chief deputy obviously is to make sure the legal functions are being taken care of, to be that facilitator with the attorney general, sometimes provide direction if the attorney general isn't available on an instant notice, and also to make sure that divisions like Amber's have the resources they need, have the staffing they need, have the communication they need so they can do their job on a daily basis with the direction and kind of the scope that the attorney general wants to go on a particular case. So I think it's keeping those lines of communication open, being responsive, and also providing clear direction so that we can delegate to great leaders like Amber and her team without having to micromanage everything daily. That's not leadership, and that doesn't get the job done. You've got to set the direction and put excellent people in place. And happy to say the results, we'll talk about that later in this webinar, but the results have been pretty incredible in Kansas over the past 3 years under General Kobach. So thank you for this opportunity, and it's great to be here.
Thank you so much, Joe. We'll have lots of questions for you, no doubt, throughout the webinar. Let's get started talking about some of the Kansas-specific state laws, how it works in your state. So if we can go to the next slide, we're going to do our consumer protection lightning round like we typically do, and this is a great thing for our viewers so they know how it works in your state. So for the next slide, let's talk about first, how is the AG selected in your state?
Well, I'll take this one, and then I'm going to turn it over to the expert on a lot of these and weigh in every once in a while. But in Kansas, the Attorney General is a statewide constitutional officer under the executive branch or department, if you will, and elected every 4 years, no term limits. And General Kobach is in his 4th year, so he's running for re-election this year.
Thank you. And so, Amber, it sounds like you're going to talk to us about how consumer protection is organized in your office. Um, and you guys call it the Public Protection Division, correct?
Correct.
All right. You have some normal things that fall under consumer protection and some that are surprising. So tell us about these, Amber.
Yeah, absolutely. So we do have consumer protection. It is the largest section under the Public Protection Division. In addition to that, we have our antitrust function under this division. Then we have what we have referred to as the Charities and Financial Scams section. That deals with the charitable solicitation oversight. And then open government enforcement is a function within our division. And so we receive and review, investigate, and then when necessary, take enforcement action against entities, public bodies that have violated our Open Records Act or Open Meetings Act. And then finally, we have the Kansas Sexually Violent Predators Unit. That is the area that administers our Kansas SVP Act. It's a post-incarceration civil commitment proceeding for some of the worst sexually violent predators.
So, Amber, those seem very different. How does that just logistically impact your staff? Because you have some criminal, some civil, some in regard to public records. Any more color you can add?
So the logistics, it is interesting. They are not all on the same processes or timelines. It's not necessarily the same area of law. We've got different skill sets and expertise among those areas. The first three I noted, the consumer protection, the antitrust, and then even to a large extent, that charitable and financial scam section, they do operate largely within the same body of law. And some similar processes in their practice. However, the next two areas really tends to be pretty independent of the rest of the group. The SVP, they are very isolated just because of the nature of the material they deal with. They have some additional security provisions and they just don't sit. They are not co-located with the rest of our division. Because of some of those considerations. The Open Government Group does sit with the rest of the division. And it's nice because even though we've got folks practicing in such different areas or investigating in different areas, there's still a lot of collaboration among all of the attorneys. The open government attorneys sometimes have had experience in areas outside of what you would imagine that can lend itself to CP cases. Or conversely, when an open government issue arises, that some of the background information is unique, but still necessary for their analysis, they can lean on the CP attorneys or some of the investigative staff to get some of that background familiarity in order to continue their review of the case before them. So it's different, but it's also very interesting. It keeps things very interesting among the division as a whole.
And Amber, I'm just curious, what type of staff do you have? Of course, you have attorneys, and it sounds like investigators. Do you have any other unique positions?
So we do have attorneys and investigators. We have an administrative staff that supports just in our complaint intake process and then the administrative management of our cases. Beyond that, a special agent in charge, and investigative staff, attorneys, and admin and paralegals. That's what makes us up here in the division.
Well, thank you. So let's go to the next slide and talk about how our consumer protection priorities set in your office.
So Joe mentioned a little bit of this, and I'll certainly allow him to fill in anything that I don't hit. But we do have two tracks, primarily the complaints that we receive. We work them, we investigate them. And when we start to determine that there's maybe a pattern or practice of behavior in an industry or with a particular supplier, we look at that a little closer and the response escalates. That's where we may look at enforcement action on a state level with our state suppliers. Then beyond that, we pay attention to what's going on in the region with the surrounding states or any other national efforts for those larger suppliers that do operate across several states or across the country. If there are just trends that we can see in other states as well, we pay particular attention to that to determine if there's an opportunity to collaborate with our neighbors or look into something along the lines of a multi-state.
And if I could add to that, I mean, we learn things as we attend national meetings, and as the issues kind of percolate. Sometimes never heard of an issue, and then you're at a national AG meeting and you hear something for the first time, and it's very troubling. And so if Amber's at that meeting, or I'm at that meeting, or the Attorney General's at a meeting, we can come back from that and say, let's start looking at this. Is that an issue? Is it impacting Kansas? As Amber said, is it impacting the region? And then we'll dig into it, a little bit more. Sometimes issues are brought to us, kind of out of the blue. Is this something of interest? And then, if it is, we'll start digging into that a little bit more as well. And, sometimes the AG has priorities. He's got young kids as well. And, he'll see things and it doesn't sound right, or people will reach out to him when he's, around the state, and we'll bring that back. And then, we'll do our due diligence and make sure, if there are issues there, then we can start the investigative process. If there are issues there, but they're not impacting Kansas, then obviously that's something that's not going to be a priority or of interest at all. So we've got to balance that all out. And, in Arizona, I know it happens here in Kansas too, sometimes more local than national, but you'll see trends in those consumer complaints. And I know Amber's team screens those, and if we're starting to see certain trends by companies or by issue, then we will track that and maybe investigate that, or at a minimum put out a consumer alert. And the consumer alerts here in Arizona get a lot of attention. People pay attention to them, especially the local media, and that can go a long way to helping consumers deal with scams that are out there or misleading business practices well before a lawsuit could take place, and the long timeline that could transpire to actually get a result. So that's a way to impact the community up front and quickly as well, based on things we're seeing and hearing.
Well, thanks, Joe. So let's talk about those complaints. There's some really impressive numbers up there. Amber, do you want to describe them and how these complaints work in your office?
Yeah, so we've got a variety of ways that a consumer can send a complaint to us. They can walk in and fill it out. They can give us a call, an email. We have an IR form, an investigative request pathway. They can proceed online. Then we take other referrals from other state agencies if they don't get to the right agency. So we've got a pretty wide funnel of ways to get complaints on our radar. So once we do have one of those complaints, again, a couple different paths that we can proceed on, but ultimately the priority that we work towards here in our division is trying to make a consumer whole, trying to identify what their losses were. And then again, if it's a more widespread pattern and it does elevate, we'll start contemplating penalties or recovering our investigative fees. So in that, and then in addition to the multi-state cases that we've been involved over the years, we've got total recoveries and judgments since AG Kobach took office, $183,637,000, roughly, since he took office. And that does include some of those larger national settlements, but state settlement funds for this past fiscal year, this past reporting year, were $3.2 million. That's primarily some of our state suits, state settlements. It does include a pretty hefty chunk of consumer restitution. And then by the numbers, we receive somewhere around 4,000 cases every year and try to close just as about as many. And that's it's been a little inconsistent over the years. We did see a slowdown 2019, 2020, and then we saw some atypical spikes. But looking over a longer term, it's about 4,000 a year that we really try to work one in, one out.
All right. So let's move on. Let's start talking about your consumer protection law, and I'm going to pass it off to Andrea, who's going to ask you some of those questions.
Yeah.
So if we could go to the next slide.
Great. So starting first with, what is your primary consumer protection statute?
So our Consumer Protection Act it's KSA 50-623. That's where the act starts. It includes suppose what I would refer to as typical consumer protection provisions that we see. And then it also ties in a host of other statutes that usually come by way of legislative amendments over time. So one example is a fairly recent piece of legislation. It's the age verification of website content that's harmful to minors. So that primarily deals with just adult websites, pornographic websites, if they aren't properly shielding their landing pages or verifying age. There's just a litany of other what we call odds and ends that flow into our enforcement authority, primarily based on that consumer supplier transaction. As that changes over time, the nature of the transactions may change over time or evolve with different business practices or technological improvements, and we try to keep up and change with it. And sometimes that means requesting additional legislative authority, as we'll get into later with respect to AI.
Got it. So are you able to conduct pre-suit investigations?
Yes, we have a subpoena authority. I'm working on maybe training Joe to Kansas language. Though a lot of our neighbors refer to it as a CID, and I think at times we even refer to it as a CID, but it is a subpoena under our statute, and we have that authority.
And if I could just amplify that, that's an important tool for attorneys general. You've got a lot of latitude, and it's pre-suit discovery. But I think as important, and maybe in some ways more importantly, as a governmental entity, you got to conduct that with proper due process. And it's a way to make sure that before a state acts, while this is not a criminal proceeding, it still is a civil proceeding. There's a penalty that can attach at the end of the process. So I think it's very important for states to use that to do as thorough investigation as they can with the timeline presented. There has been a trend recently where some states are hearing information and filing suit prior to issuing a subpoena or CID. I think that's interesting on a lot of fronts and maybe problematic on some others. So I think it's important for states to use those tools. It also puts the company on notice to say, hey, if we're doing something wrong, some companies will say, let's talk. Let's fix the problem. Thank you for bringing this to our attention. Can we resolve this pre-litigation? I think it's always important for state attorneys general, if the other side is a good faith actor, to take them up on that, even after litigation's been filed. That's part of being a good actor in government, and that's good government to listen to that process. Sometimes it's too one-sided with the power of the state, and we try and bring that balance. We did that in Arizona, and I'm glad and proud to say that that's been done here in Kansas before I got here and while I'm here. So it's a second bullet point, but I think it's very important to the process, and I hope states don't lose sight of that down the road.
Can I follow up on that? Because Joe, I mean, you made some excellent points there, and I just wanted to follow up with a couple of points too. I mean, I can tell you that from, I spent a long time sending CIDs and getting responses, and then coming to this side where you're defending companies who are receiving CIDs. A lot of times, receipt of a subpoena or CID, even, it can be a stressful experience, right? Because it disrupts the business. They can sometimes be asking for a lot of information. To your point, the AGs generally enjoy really broad authority to ask for that information. But one of the things that we remind businesses frequently, right, is that, the alternative is they could just file suit and they could be asking for this information in discovery. And that can be even more disruptive and more problematic. And so, I wholeheartedly agree with you that the pre-suit investigatory process, while from a defense side, it at times can feel like it's unfair because you're getting one-sided discovery. It actually is, to your point, it's allowing the state to do its due diligence in a process that can keep you out of a litigation track and that is generally kept confidential from the public. And so to the extent you conduct that investigation and find nothing is there, these can go away without it getting splashed all over the news, right? That these accusations are out there, which has a lot of impact on a business when someone, goes off and sues like that without conducting that initial discovery. But I really also want to emphasize this point about being able to talk, right, and speak. I mean, Joe, you're one that has done that now across multiple states and always been available to discuss, right? And that doesn't mean we're always going to agree, but having the opportunity to sit down and talk through some of these issues is critical. I guess a question I have on that front is do you have any sort of suggestions or guidance for the business community as to best practices with that kind of engagement? Is it, are there things that are sort of pet peeves in your mind or wrong ways to approach it? Or is it really just, just come, be transparent, let's have a dialogue and see if we can, address any concerns that you might have?
Yeah, I'll give you my perspective, and then I certainly want to hear Amber's as well on this point. I think, to the extent you can introduce a company when there's not an issue and show some of the good things that they're doing, that's best. And to do it on a time schedule that, hey, don't grab somebody at a meeting and just try and give them, 15 minutes of information. Make sure it's thoughtful and on an important point of what they're doing and maybe their practices, especially if you're seeing trends with other competitors in the area or the business model in general. I think it's also important that whether it's a letter with questions or a subpoena/CID, that really sets the tone of where things are going to go. And some businesses will ignore, or they'll kind of poo-poo it, or they'll go scorched earth on the response. And I think that is a devastatingly wrong approach for a company to take. We're already off on the wrong track. The state has time, it has resources, it has the authority pre and post suit. Not ideal. And be transparent in those productions. Don't if we agree to rolling productions, make sure they're timely and they're fulsome. Things come up, we're agreeable to extensions. But if we think you're playing games, that's where I think the process can bog down and stop. And now we're skeptical of the position that you're taking, because it doesn't seem like the process is trustworthy from the responses we're getting procedurally or substantively. And then when there are opportunities to discuss, make sure they are substantively fulsome and not just some overview or saying, we're doing this without substance to back it up. Because high-level presentations to say we're good actors when we know we're seeing things either through our discovery or in the media doesn't necessarily, get you to a point to maybe get something resolved pre-litigation. And if there is wrongdoing, and the company has to be open to that and has to be responsive to candid advice from their counsel, inside counsel or outside counsel. Make concrete steps to remedy it and come to a resolution with a state versus just saying, well, we'll do better next time. If there's wrong there, kind of have that, it's not technically a safe harbor. Work through that, and that can be negotiated in terms of negotiations to see if you can get to that point. But if that's not transparent and honest in the beginning, and then we get into litigation and find out, just trying to stiff arm us pre-litigation, I think that prolongs the case and certainly will increase the remedies that will be sought by a state post-litigation.
I agree. I think that cooperation and good faith in a business's response to either just an informal inquiry or a subpoena from us is the best way to go. If it just becomes more difficult for us, if we need to add time or resources in either obtaining the information or going through excessively voluminous information, we're not going to be as inclined to be cooperative throughout the rest of the investigation and perhaps ultimately the litigation. And it goes the continuum of you can blow us off and not respond, and that's definitely a strike. Or if we just get documents dumped that are unmanageable, that's not really good faith either. And then to the extent that it is technically complex or perhaps unique, or you have proprietary systems that we would benefit from an explanation, and you do reach out and offer to walk through what this billing system does, or what this document entails, or why, if you want to give us some background information, we're only going to benefit from a more thorough and accurate understanding of the information provided to us. So the bottom line is going to be cooperate in good faith, and I think that's how you would achieve the best possible outcome.
Great. Well, that was all really, really interesting. Turning quickly to some of these other questions, I guess to Paul's earlier point about how the pre-suit investigation process happens largely out of the public eye, are subpoenas confidential, and are the answers confidential?
No. So subpoenas, they're not statutorily protected or confidential. The responses that we get are subject to a discretionary exemption from disclosure under our Sunshine Law, under the Open Records Act. So, KSA 45221 A11 provides that we are not required to disclose records of subject of an ongoing investigation, and we do, as a practice, utilize that. So while we don't have that statutory protection, we also have avenues to not produce those documents.
And can a party move to object or set aside a subpoena?
No, we do not have that provision here.
And how can you enforce compliance?
So if we need to enforce compliance, we would go to a district court. We can go so far as to enjoining a supplier from operating in the state if they do fail to comply continually. So that is a pretty heavy-handed response, but that's the max of our authority.
Yeah, and on that point, I mean, to the extent there isn't compliance, and then we have to go to a state district court for enforcement. To Paul's point earlier, now something that was, maybe quiet, could be held confidential. There's now, one, a public filing, but two, probably there's a statement by the Attorney General's office or a press release saying we now have to go enforce this because they haven't been cooperative. So now you've opened that can of worms, and you have to deal with all of that from a media and disclosure side on the company perspective, as well as at the end of the day, 9 times out of 10, if not more, the state's going to prevail on that because these are broad powers to get this information pre-suit to see what the next steps are, if any. So if you're taking that tack, that's pretty extreme. And as they say, that gun can kick harder than it shoots. So be careful with that.
Got it. And do you have a statute of limitations for AG actions?
We do not.
And do you have to provide pre-suit notice?
There's not a statutory requirement to provide pre-suit notice, but I think, as we've said, throughout, as a best practice, you're going to hear from us a number of times before any litigation is filed. So it's not ever going to be a Monday morning surprise to see a notice of a filing from us.
Amber, quick question on the SOL statute of limitations. Am I correct that that's through a court case that you don't have it, or is it in statute?
I believe it is the court precedent. So we don't have it. And I believe the court determined there was not one. And it's sort of an area where we are very happy with that finding.
Okay.
And
thank you.
Yes, we appreciate that. And we don't rock the boat.
Great. Well, turning it over to Beth now, I believe we can go to the next slide.
Thanks. So we've talked a lot about negotiations before suit and what things may happen at that point. What about resolution? So what types of settlements is Kansas empowered to enter into?
Statutorily, consent judgments is the vehicle that we would enter into. Then we can also enter into an assurance of voluntary compliance. We're really hesitant because they just don't have as much protection surrounding those. They're not our preference. I understand other states' laws treat them slightly more favorably, but they're not our preference. And so we typically don't pursue those options.
Okay, but there is a AVC pursuant to statute. It's just not your preference to.
I don't even believe it's referenced in statute. Consent judgment is the
Okay.
only vehicle referenced in statute. But
Okay, so that's different from some other states, which, yeah, like you were mentioning, have some specific protections and provisions related to AVCs. Okay, interesting. And when you're obtaining the remedies under those settlements, so what's your civil penalty authority?
The KCPA allows $10,000 per violation. That is, it can also be a daily. If it is an ongoing pattern of conduct, it can be a $10,000 daily. The statute also provides enhanced penalties of an additional $10,000 if the consumer is in a protected class, which is defined as military, veteran, military spouse, elderly, somebody over 60 years old, either physically or mentally disabled, or if the individual is non-English speaking, if English is not their first language. And then we can also recover fees for investigation and costs.
Okay, and restitution or disgorgement, are those available under your statute, or does Kansas pursue those?
Yes, absolutely. Restitution tends to be our focus when we are proceeding. And we do not have a specific statutory provision for disgorgement, but in considering an appropriate restitution, we can always factor that in. But I think with the civil penalty statute is, yes, it's nice as it is. It's typically just consumer restitution when identifiable and penalties that we pursue.
And when you're looking at the different types of remedies, are there times when you don't get certain ones? And if maybe you can elaborate on why. So injunctive relief or penalties, are those appropriate in every instance?
Typically, it depends, though. If we have a situation where the pattern of bad behaviors is so egregious, and maybe it's a company that is not liquid or it doesn't have the ability to pay a large penalty, we're going to be satisfied with injunctive relief that just prohibits them from operating in the state anymore. It really just depends on what the bad behavior and the violations are. But there have been times when we have, leaned for some just really meaningful injunctive relief and making the consumers whole and not pursued penalties.
Yeah, I also think it's the nature of the case. I mean, obviously these big national cases dealing with some of these complicated business models, we've seen them over the years, that's injunctive relief was, and in addition to the money was important in the opioids case, tobacco settlements, some of the other tech cases we've seen over the years. So that's where it's really, I think, critical to change that behavior going forward. And as Amber said, on the local ones, it's the penalties and the restitution that is the stick. And then if they're really bad actors, making sure they don't operate in Kansas in that business model going forward. You're not most likely going to have business model injunctive terms for the local matters.
Right. So the injunctive terms can get quite complicated or prescriptive in certain instances, depending on the case, as you were mentioning. So that,
Right.
I guess, does kind of bring me to the next question of, do you ever sunset your settlements or portions of those?
Yeah, we'll have terms in them, depending again on the nature of the case, and the bad behavior, if it's been identified and remediated. It will depend, but we have entered into agreements where the terms will sunset, but sometimes with a lot of the smaller local issues where it's just a pretty egregious situation, taking advantage of elderly consumers or something like that, we'll seek a permanent injunction, a permanent remedy, keeping them from ever operating again in this business or what have you in the state.
We have a
So-
local matter right now where we filed where that's front and center. And if we can get to resolution with significant restitution for what was alleged, almost to make certain people whole in the case and to get them banned from future operation here in the state. That's the victory in the case. You know.
And how are you able to enforce the injunctive terms? It sounds like since you all are using consent judgments, you may have more remedies for that.
Yeah, we would go back to the district court to enforce if we were having issues with that. That again is one of the reasons the AVCs are more difficult to enforce and why we don't prefer them. They have some less certainty and structure around them, and then over the course of years, if they're not formalized in a court filing or anything like that, then we are just slightly more likely to see them get lost in the shuffle or not have as much visibility. So we certainly don't prefer them. Yeah.
So switching gears from the settlement resolution terms, do you all have specific laws and remedies for price gouging and auto renewals? And these are questions we like to ask of all the different states because some of these are very specific and interesting state by state, whether there are laws that exist.
We do have a specific law for price gouging, though it's referred to as profiteering during a disaster in our state. It tends to be difficult to prove. Not only do you have to have a declaration of disaster in effect, but the burden to show that the supplier's price was unjustifiable. It can be influenced by a lot of other factors: upstream supply constraints, transportation cost increases. All of those other things make it a fairly complex analysis and not as often pursued fully.
Yeah, and that is an area that really differs by state because not all states require a disaster declaration, or they have different requirements for what meets the type of supplies that are subject to the law and things like that. So it's always interesting to hear the different nuances. Do you all have an auto renewal statute?
No, we don't have any specific provisions for that, but they would just be evaluated under the deceptive or unconscionable standard, depending on the circumstances.
And what about a comprehensive? Oh, go ahead.
I was just going to say it was an interesting juxtaposition. I don't think the law has changed. It may have, I doubt it. But Arizona never had a price gouging statute. So everybody would come to us and ask, especially in times when the fuel would spike or something, or there was a micro disaster in Arizona, and there was no remedy for that in Arizona.
Yeah, and I know some states have been pushing. I don't know specifically for Arizona, but there has been different legislative efforts throughout the different disasters that have taken place over the past few years.
Sure.
Do you all have a comprehensive privacy law?
We do have an act. It provides for safe handling and secure disposal of sensitive information. It's the Wayne-Owen Act.
Okay, and then do you have any new noteworthy consumer protection laws recently? And I think that we have a whole slide for that. So I guess a little foreshadowing for you.
Yes, we've got quite a few, and I want to be sensitive.
Go on to the next slide. Yeah,
so I'm gonna move through them pretty quickly.
Thank you.
Yeah, e-cigarette regulation. It's putting some regulation on the manufacturers and sales of e-cigs. Age verification on App Store developments. Chatbots, that's one we want to get into later, so I'll just breeze right by that one. Crypto ATM regulation is a new one that came up this year. It requires some disclosures for crypto kiosks. It caps some fees. It's really designed to protect scam victims that may be running to a crypto kiosk from losing, significant amount of money. Two provisions relating to the Landlord-Tenant Act. Right now, we have a Supreme Court case that has found that the landlord-tenant is not anything enforceable under the KCPA. One of those provisions, one of those statutory amendments would change that Supreme Court case, and then as it would relate to constructive eviction and uninhabitability. And then the other one has to do with the sale of units of a landlord selling any residential units under certain requirements They would have to offer to the tenants first. The Digital Right to Repair Act, it creates a right for consumers of digital electronic equipment to have the right to repair, accessing documentation, parts, to those devices. Veteran Benefit Service Regulation, it limits the fees that you can receive for assisting veterans in benefit matters. Proxy Advisor, ESG, it requires proxy advisors to make certain disclosures. Consumer Legal Funding Regulation would when a funding company purchases and a consumer assigns the right to receive the proceeds from litigation or a legal claim, it puts some requirements on the funding agreements, some regulation of the conduct between the lender and the borrower. And then accessing and filing fees. It requires anybody soliciting for or retrieving documents from the state or federal government to disclose essentially that they're not a government actor, clearly in certain ways, to avoid scams there. So that's a rundown of some of the things that look, if they are successful, and again, our legislative session is still ongoing, but those would be areas added to our purview if they do pass.
Really appreciate the rundown. I think we're turning to Paul next to cover our big topic of AI with you all.
Yeah, so just to kick us off here, Amber, I think you alluded to this earlier that I think it's funny when we talk about AI and protecting children and chatbots and these kind of topics where when our various consumer protection laws in the states were passed, which was generally like in the 70s, I don't think anyone would have contemplated the kinds of issues and harms that can occur today. And even though general UDAP authority may be broad and may be applicable to new technology and emerging trends that we see, having specific statutory authority that address some of these areas can become really crucial just because, this is not something that was ever contemplated by the law. So I will turn it over to y'all and maybe we can jump into your chatbot bill and just talking about, the work that y'all are doing to try to address the potential harms that can occur through the misuse of AI.
Sure. So I'll give a little overview on that bill. That's Senate Bill 405. And it is a bill that would make it unlawful for a person to essentially train artificial intelligence chatbot to do a number of itemized things. Most probably relevant to what's going on is simulating a human interaction relationship, developing an emotional relationship with a user, posing as a healthcare provider, either physical or mental, and then also encouraging the user of the chatbot to contemplate suicide, to support isolation, some of those things that have most unfortunately driven some individuals to either take their own life or attempt to take their own life, run from their house, all of those things that we're seeing in the news. It seeks to put some safeguards around our AI chatbots to avoid those unfortunate situations. So that is what the act does. Joe, I didn't know if you wanted to speak at all to what the Attorney General has undertaken. About 3 or 4 months ago, we started this fairly large investigation effort.
Well, I think the bill is an enhancement to what our authority already is. I think there are broad powers still under consumer protection for any misleading product or service. This just, I think, strengthens the penalties, gives an additional option, additional tool in the toolbox to the Attorney General's office. But the Attorney General wanted to send his own letter to the AI companies versus a multi-state letter that went out with maybe a little different focus. We think it's a broader harm, and we wanted to kind of take that on ourselves and see. We've had some issues here in Kansas with some of the chatbots impacting young Kansas children. So it's an important issue. And, protecting children has always been, I think, a big theme of consumer protection, dating back to the big tobacco settlement in the 1990s. And it's ever present. And I think it's even more pressing now. While AI is great, there are scary facets to it. And the technology can't get out ahead of being deceptive and misleading or very problematic, especially when it comes to children. And that's what we're looking at. And we're going to do our best to safeguard Kansans if we think there are violations of current law or if a new law is passed.
Yeah, and look, not to put y'all on the spot with this, but Joe, the way you just framed it, you made the comment, AI is great, and I do think that there are, I think it's not disputed that, the technology itself, right, has great value. And I think where y'all have been coming from, and you've seen other states, get more active, is ensuring that in the early stages of designing new offerings to the public, that these kinds of concerns are contemplated and built in from the outset. And you're absolutely right. Protecting children has always been a strong theme of the AG community. But, like I was alluding to at the outset of this, sometimes it gets tricky as to how do you balance, from y'all's perspective, both encouraging the innovation and new technology and the benefits that can come with it, but also ensuring that it's done in a socially responsible way, right? And ensuring that you are protecting the citizens of the state.
Well, and sometimes these issues are known and they are debated and analyzed at these companies in early stage, and those safeguards are disregarded and any warnings are omitted to the public to advance the technology, to advance the profit, to get out ahead of things. And we've seen it in other industries over the past 15 to 20 years. And in some ways, we've seen it back, like I said, to the tobacco settlement as they marketed to children. So that's where discovery, pre-lit, post-lit, discovery can get into some of those statements. And companies need to be very careful of it. And sometimes they're aware and they're not mindful, and maybe they don't care. And if that's discovered, that's the problem. And that's where AGs are going to be jumping in with both feet, because that's unacceptable.
Yep. Well, I think that's actually a nice segue to then move on and talk about, the Attorney General's testimony and, his focus on this bill and exactly why he feels like it's important. So I think we can go to the next slide. And Joe, Amber, I don't know if you want to make any remarks, about his testimony before we jump into showing a clip from it.
No, I think it speaks for itself. So
yeah,
play it.
Okay, yeah. So let's go and play it.
A child?
I think that's a very good question for the Attorney General.
Thank you, Mr. Chairman.
Any other questions? Same from our Attorney General, Chris Kobach, and welcome to Senate Fed and State, Mr. General.
Thank you, Mr. Chairman and members of the committee. Good morning. I think you'll find this a very interesting topic, and I think it's one that everybody on the committee, Republicans and Democrats alike, will want to engage and have some thoughtful input on. I don't know if you noticed the front page of the Capitol Journal on Friday. I know that Friday's a light day usually around here, but if you got it, you might have noticed that there was an article about Federal District Judge Robinson in Kansas City imposing a penalty on 5 attorneys who submitted a brief, and in that brief, an AI app made up cases, made up quotations from those cases, and she was imposing sanctions upon the attorneys for not, going through and seeing if these cases were real. And interestingly, I heard about this 3 years ago when a New York judge did the same thing, imposed penalties on an attorney who filed an AI-generated brief. It is infusing all aspects of our lives, and even in the legal world, it's getting attorneys in trouble, and they should be in trouble for relying on AI to do this. As your state's chief law enforcement officer, it's my job, obviously, to protect Kansas consumers, protect Kansas against crime, and also to anticipate threats. And if I don't have specific legal authority from you, the legislature, to address those threats, then to ask you for the authority to address those threats. And that's what I'm doing today. As I'm sure most of you are already aware, artificial intelligence chatbots have created a host of problems, especially for children. They have encouraged teen suicide. They have generated child sexual abuse material. And there's a case of that coming from Topeka, and it's in footnote 2 of my testimony. AI has created sexualized conversations with minors, has pretended to be a licensed therapist, and of course, it, in many instances, forms sycophantic and unhealthy relationships with the user. And if that user is a minor, then the dangers are even higher that that user may start thinking of this chatbot as a person. What starts as a 13-year-old girl asking the chatbot for advice on how to dress at school, then becomes the same girl asking the chatbot for advice on how to talk to a boy she met at school, and then it becomes relying on that chatbot for advice on how to deal with her depression when things don't go well with that boy at school. It is truly, truly troubling, and I'm sure many of you have seen some of the material generated by these chatbots. So we have this bill to protect Kansans against this type of AI abuse. There are sensible exclusions for responsible business uses, as staff mentioned to you already, but it does take powerful steps to stop and discourage AI chatbots being used in the ways I've described. And as was mentioned, citizens are also empowered to bring a private right of action. I think this is really important in this bill. There are some areas where you may not necessarily want citizens empowered to have a private right of action, but here, this is one where parents who are vigilant and seeing something going on and seeing what a chatbot is encouraging their kids to do may realize that they can hire a lawyer and then take action. We have, of course, the Kansas Consumer Protection Act already, which protects Kansans against misrepresentation and fraudulent advertisement and the like, but that doesn't really cover the gamut of what the threat is from these AI chatbots. So this would, build upon that. I want to point out again that this really isn't a Republican or a Democrat issue. As you may be aware, several states have already passed similar, although not identical, AI bills. California.
We're good there.
Yeah, and I mean, look, Joe, Amber, I welcome, some closing thoughts, from the general's discussion, but I think he really, I thought, very nicely captured this sentiment that we were just talking about of, that there is, every state enjoys this broad consumer protection authority, but when we're dealing with emerging technologies is when we have to start to address it through perhaps some very specific legislation. And undoubtedly, that legislation is going to evolve and adapt over time to address, the way that technology evolves and adapts over time as well. But again, it's all with that same ultimate benefit of protecting the consumers of the state and ensuring that, businesses are operating in a fair and transparent way with the public.
Yeah, that's exactly right. I think Joe stated we've got pretty broad authority right now, but with it being such a new and emerging issue, the direction from our legislative body, all of the information on where the priorities are, something that we desire to have. So we're not just kind of figuring it out on our own, because there are just so many areas in some of these new technologies and new business practices. And so, yeah, while the authority is arguably there, the refinement and the additional focus on the specific issues is necessary as well.
I would say the authority is there, and this is an enhancement of it, because these are old school misrepresentations, omissions, and it's targeting children. And any company should know that if there's an issue involving children before a judge and jury, they're going to be very sympathetic to that cause of action against that company, especially where it's leading to suicide, self-harm, harm to third parties. It can be very troubling. So I think we have the basis under current law. It may be a little more difficult to get there, but with any enhancements, we're there. And so we just ask these companies to do the right thing, protect those children where they can. And if not, then that's where attorney generals will step in to right that wrong, like we've done for decades.
Well, I think that is a great place to close us out here as we've hit the top of the hour. So once again, Joe, Amber, thank you guys so much for your participation and sharing your information with us and with the audience today. Thanks again to my colleagues at Kelley Drye. As we mentioned, if you have any questions or any follow-up from today, please feel free to reach out to any of us. And with that, we will wrap up today's presentation. Thank you guys so much.
Thank you all very much. Have a great day.
Thank you.